Welcome to Lecture 1 in this series on critical reflections on the EU's data protection regime, GDPR and the machine. The book was edited by Róisín, Costello, and me, Dr. Mark Leiser, and it brings together 9 chapter-length interventions on the GDPR's first 5 years in operation. It does not offer a commemorative account, and it does not reduce the regulation to a binary verdict of success or failure. Instead, it asks how the GDP works when legal doctrine enters public administration, platform, markets, technical design, litigation, and institutional enforcement. The title, GDPR and the Machine, captures that concern. Data protection law operates inside larger systems of power, and those systems also reshape the law. The GDPR entered the legal imagination with unusually high expectations. It promised a more integrated and harmonized framework across the Union, stronger individual control over personal information, and a standard capable of influencing regulation beyond Europe. Yet, us editors identify reason for caution from the outset. The regulation remains overly complex. It gives national supervisory authorities broad powers, places substantial weight on the lead supervisory authority in cross-border cases, and continues to rely heavily on notice and consent, even though that architecture had already shown serious limits under the Data Protection Directive. The book, therefore, starts from a productive tension. The GDPR possesses remarkable normative ambition, but ambition alone cannot guarantee practical protection. The volume takes a deliberately selective approach. It does not claim to catalog every judgment, enforcement action, or doctrinal dispute. Instead, it assembles episodes that expose the regulation's capacities and shortcomings. Each chapter asks some version of 3 questions. What changed when the GDPR arrived? What effect did the relevant rules have in practice? And what unresolved issue will shape the next phase? That structure allows doctrinal analysis to sit alongside empirical evidence, institutional criticism, and political economy. The result is a portrait of a field that developed with extraordinary speed. Courts, data protection authorities, businesses, and civil society have all participated in giving operational meaning to a text whose central concepts remain contested. 4 fault lines connect the chapters. The first is power. Who can collect, infer, classify, and decide, and what can the affected person see or contest? The second is autonomy. When does consent express genuine self-government rather than acquiescence within a constrained market or manipulative interface? The third is risk. Who defines the relevant harm? Whose perspective determines severity? And how should organizations convert abstract rights into anticipatory governance? The fourth is enforcement. What becomes of a substantive right when the institutions responsible for vindicating it lacks resources, coordination, or procedural clarity? These themes overlap. Invisible power weakens autonomy. Poorly framed risk assessment can normalize structural harm. Weak enforcement can turn strong rights into formal promises. The first 2 chapters approach governance from opposite directions. Tiemann Weisman begins with the person already inside an administrative data system. Public authorities may create dossiers, labels, and scores that influence access to benefits or other public goods while leaving the citizen unable to understand or challenge the informational case against them. Bart Shermer then turns to the organization before processing begins. Article 35 requires a data protection impact assessment where processing is likely to create high risk. One chapter therefore asks how law responds after power has been invisible. The other asks whether governance can anticipate and redesign risky processing before harm becomes embedded. Together they connect due process, transparency, organizational learning, and accountability. Chapters 3 and 4 examine the legal event that supposedly converts data processing from prohibited interference into authorized activity. Costello and myself treat consent as both a lawful basis and a claim about autonomy. Our distinction between thick and thin consent asks whether the user has meaningful alternatives, adequate understanding, and a genuine ability to refuse without detriment. Leiser applies that problem to surveillance advertising. Contractual necessity, legitimate interests, and consent each encounter difficulty when a business model depends on extensive behavioral monitoring and concentrated platform power. The combined lesson is not that consent has no value. It is that a click cannot carry the full normative burden of legitimizing an entire socio-technical system. The next group of chapters widens the field of vision. Ziapka, Sano, and Nelson show that a formally gender-neutral risk framework can remain substantively gender-blind. Femtech reveals embodied, collective and societal risks that an atomized model may miss. James Kneale follows the Schrems litigation to ask whether fundamental rights standards can travel with personal data across borders, particularly to the United States. Van de Poel and Melgiri then challenged the idea that the GDPR has remained static. The AI Act, Digital Services Act, and Data Act can silently reform the practical meaning of data protection without amending the regulation's text. These chapters show that context, jurisdiction, and adjacent legislation continuously reshape the GDPR. The final two chapters ask what happens when the GDPR meets other legal regimes and when a breach reaches the remedial stage. Catherine Nolan argues that lawful processing rarely depends on GDPR compliance alone. Sectoral and digital legislation can mandate processing, provide legal basis, or create overlapping obligations, but charter rights continue to supply a second tier of scrutiny. Róisín Costello then imagines Article 2082 and non-material damage. The damages cases expose the regulation's dual identity. It supports the internal market, yet it also recognizes lived harms, such as loss of control, apprehension, and fear. These chapters prevent us from treating data protection as a self-contained code. It operates within a wider constitutional and regulatory network. The most useful way to approach the series is not to ask whether the GDPR is simply strong or weak. Four distinctions produce better questions. First, distinguish text from practice. A right may look clear when its implementation remains uncertain. Secondly, distinguish individual from structural effects. Data processing can harm a person, a group, or the conditions under which social life takes place. Third, distinguish rights language from market function. EU data protection law protects fundamental rights while also organizing the circulation of data in the internal market. Finally, distinguish rules from institutions. Procedural design, regulatory resources, and enforcement culture determine whether doctrine changes conduct. Those distinctions form the analytical method for the lectures that follow. The core takeaway is that the GDPR does not operate outside the machine. Institutions, markets, interfaces, and technical systems mediate every promise contained in the legal text. The book studies those mediations and asks where power, responsibility, and protection ultimately settle. Don't forget to check out the next video in this series, where Timon Wiseman examines invisible power, secret administrative classifications, and the limits of the GDPR as a form of procedural protection.